on the newbie, so I better listen hard.
We'll call this meeting to order. This is a workshop meeting of Commissioners Court of Grimes County, Texas. Today's date is Wednesday, August the 28th. It is 1 p.m. We are meeting at the Courthouse Annex at 114 West Buffington Avenue. There is a quorum present. Meeting is called to order. I'll turn it over to TAC, our Texas Association of Counties.
Thank you, sir. Thank you all for coming. I'm really excited to see the crowd that we have. My name is Lori Floyd. I am your Human Resources Consultant with Texas Association of Counties. And today we're going to talk about some unemployment process. So I'm going to kind of go through how unemployment works, what the process is, how the eligibility rules, things of that nature, and then kind of give you guys some tools to help with unemployment. So, knowing the documentation that you need, things to consider when termination for unemployment and things of that nature. If y'all have any questions along the way, please stop me. I'm open to questions in the middle, because you'll forget. If you're like me, you'll forget by the time you get to the end. So please, if you have any questions, please feel free, okay? So just disclaimer, I have to say I am not an attorney. This is just from the HR perspective, the HR world. If you need legal advice, I do encourage you to reach out to your county attorney, or we do have TAC Legal, so they can help and assist if you have any questions, legal questions. So unemployment, how does unemployment work? This is just the basic flow of unemployment. When a worker loses their job, they have to go file a claim with unemployment. So we may not get an unemployment claim on every single employee that leaves their job with Grimes County. If they don't file a claim, there's no unemployment process, right? So when they file the claim, they do have to register to work. They have to be available to work. And then the state is going to request information from the employer. So from you guys, the state is going to come back and ask questions about what happened, specifics of that employee, simple things like their name, their date of hire, their date of separation, their pay, and the reasons for termination. All of those things, the state is going to come back and ask those. That goes to Lucy. So when Lucy gets that request from the state, she will generally reach out to that supervisor that made that separation or is aware of that separation to gather those details. So
Lord,
yes, sir.
what is their deadline for filing a claim?
They have up to a year to file an unemployment claim.
12 months from termination.
12 months from termination. So it's really important. That, and I kind of speak to this later on too, but it's really important that as soon as an employee makes that separation, whether they quit on their own accord or whether there was some disciplinary actions, that y'all gather your facts and do that documentation at that time, because you may not get it within a couple weeks. And 8 months from now, you may not remember what happened. And if you didn't document it, then there's not going to be much hope in fighting that unemployment. So just know they do have a year. Thanks, Judge. So for eligibility, in order for that former employee to collect unemployment, there are a couple of things that the state will be asking in that process. So they're gonna, make sure the first one, has the employee worked in covered employment for sufficient time and wages. So there is a time period of where the employee is contributing towards their wages for the county to be liable for that cost. So did they work there long enough? Do they have wages in that, and kind of judging from there. So they have to have some kind of wages for them to get that unemployment. Are they physically able to work? Are they actively looking for work? Are they registered for work? Things of that nature. You can't be in the hospital in a coma and file unemployment, right? Because you can't work. You're not able to work. Now, another situation would be maybe in the, good example I like to use in the sheriff's department. Maybe in the, as a jailer, you've got a pregnant employee and the sheriff's like, fire her, she's pregnant, I don't want her here. Well, she's still able to work, right? She might be pregnant, but she's still able to work. So in those kind of situations, she would possibly win unemployment if there's not. So you want to make sure, just because you fire them because they can't work for you, doesn't mean that they can't work in another job or work in doing something else. So they do have to be actively looking for work and able to work. And then did they become unemployed through no fault of their own? So they just quit because they wanted to quit, or they just didn't show up, or whatever the case may be, then they probably wouldn't be eligible for unemployment. So you want to make sure that they quit on their own accord, No fault of the county, no fault of the supervisor. Yes, ma'am.
I just wanted to ask on that first one, the sufficient time and wages. So is there a time frame that they have to work for you before?
Yes, so, and I do have some information later on in that, so there's some periods that unemployment look at, and they look at, the first four quarters of the last 5 quarters. So if you have an employee that works for you for 6 weeks, the chances are that they're not having anything contributed to their wages for that. So that's why we encourage you guys to, if you have a bad hire, it happens, it's okay. But you know within a couple of weeks, 2-3 weeks, this employee's not gonna work out. Let's go ahead and do the separation and move on about our business. If you wait, wait a year, they're like, man, they've been a bad employee this whole year, and now I wanna get rid of them. It's gonna be a little bit harder, and it can cost a little bit more. So we wanna make sure that we are evaluating our employees as we hire them on, because if we can get rid of them sooner, if they're a bad hire, then the chances are it's gonna save money, we're not gonna have to pay that unemployment claim. Bad hires happen. Trust me, I've hired a couple of bad apples and have regretted it instantly, and I'm like, dang it, let's get rid of this person, right? It happens. But we want to give them a chance, and we want to look at their side. Okay, can they do it? Or is it just their personality? We just got to get used to it. Are they performing the job? Things of that nature. We have to factor in all of that in that decision time. Uh-oh, I got people looking.
I was going to the thermostat.
Oh, okay, I was like, I thought, I made that comment, you look back, I'm like, uh-oh, did
No.
something bad happen?
Sorry,
I can drop it down. So it's
No, you're fine.
I got it down, I just wanna see how quick it's moving, sorry.
No,
I'm
you're
sorry.
fine, no worries. So this is the process of a claim for unemployment. Keep in mind, this is the whole entire process. An unemployment claim may not go through this entire process. They may not ever file the claim, it just might be a separation, right? But this whole process can be a pretty lengthy process. So you wanna make sure, that you understand the entire process and know that it can drag on for a while, which is why documentation is key. Okay, making sure we document it through the entire process, because that's gonna be our defense in the entire process. So once there is a separation, the former employee files a claim, we have that initial protest. So that's what I spoke to in the beginning. Lucy gets that request from the state. She's gonna come to that supervisor and say, okay, what's happening, where's the documentation, what's going on? Winning an unemployment claim in the initial protest is very, very valuable. That's when you're gonna save money, you're not gonna have to pay it. At that point, if the county gets that favorable decision, okay, hey, we won, it was good separation, then it's up to the former employee to file an appeal. So we don't have to file an appeal, it's up to them to file an appeal. And they may not file an appeal. So that's why it's really important that we win on that initial protest. We give them all the facts related to it, share all that documentation up front, so that it may not go past that determination stage. When they make a determination, it's a favorable decision for us, then it may not ever go on. But if it does, either they file an appeal, or the former employee files an appeal, or the county can file an appeal. So if we get an unfavorable decision and we want to fight it, then we can file an appeal. Those appeals processes are pretty tedious. They are done in a phone hearing setting. I've been on several of them, and they are handled differently every time. But the bulk of it is that you are sworn in. Just like you're under oath, if you're going into an actual court setting, you're sworn in. So anything that you say in there it's recorded, it can be transcribed, and it can always come back and be used in some type of lawsuit or EEOC claim, something of that nature. So you've got to make sure that you're telling the facts and you're being honest, and everything that we submit in that initial protest is what comes in during that appeal process, okay? Those hearing officers do not like new evidence to come in during that appeal process. You guys are a part of the TAC unemployment fund, and so we do have assistance. If Lucy has been on several of them, but if she ever needs assistance or a supervisor needs assistance, we do have that assistance available as well. So when the unemployment hearing is scheduled, I will point out that they don't care about your schedule. It's a call-in. You can call in from anywhere. If you're on vacation, they don't care. Okay, you can't get it rescheduled. The only time I've ever seen it rescheduled was the person was actually in the hospital. Okay, but if you can prove that someone else can you testify your part of the story or witness or whatever, then they won't reschedule it. So keep in mind when they schedule that unemployment hearing, that is not something that you can get out of, okay? So you want to make sure that you never get to that spot. We want to try to prevent it from getting to that spot. After the hearing is done and it's completed, then there is a decision that's made from the hearing officer. They usually send that decision probably to Lucy. They'll send it to the former employee. Typically in that, they will give some pretty detailed information of why, what their reasoning is, and go from there. At that point, either party can appeal a second time. We really, really want to avoid a favorable decision being overturned. If we want a favorable decision in that initial request, we really don't want it to overturn in the appeal hearing. It is going to be another person looking at it at that point, okay? So we want to make sure our facts stay the same. We're not blindsided in the hearing. We have a story of a county, and I don't remember all the facts of the case, but I do remember that it was kind of a little gray area why the person was terminated, and the HR department was, sending all the information from the supervisor. From the information that was given to the HR department, it was a justifiable termination. There was all the documentation. Get into the hearing process, and then the supervisor starts saying all these other things that start coming into place that can really get us in trouble, some harassment things of that nature. They start coming out on the hearing, right, with the hearing, because now he's sworn in, so he's not going to lie. So things start coming out, so you're blindsided. So you don't want new facts coming out in that hearing. You want to make sure that your HR department knows exactly the full story, exactly what's going on, so that, because at that point, the HR director was like, I would not have appealed it if I would have known all the facts, right? We did our initial protest, and we know we're not going to win, so we don't want to waste those resources and appeal it if we know we're not going to win. And so you want to make sure that all those facts are disclosed up front. So once that decision is made from the hearing, there is a second appeal option that you can do, and there's no hearing at that point. It's turned over to a board of review. There's typically about 3 people that are appointed to that board of review, and they will look at it and decide if they're going to overturn it or not. In my time in HR, I've been in HR for about 15 years, and I've never seen one overturned in a board of review. Not to say that it hasn't happened. I have not seen every unemployment, but it's very, very hard to get that board of review to overturn with that hearing officer decision, okay? So keep in mind, initial protest is where we want to win to avoid as much of the other process as we can. Any questions on the process? Okay. Keep in mind too, whichever side files the appeal, it's their duty to justify why. So they have to defend the reasons as to why they're appealing it or why they think they're right. The other party, if they won, they just sit back and listen, okay? So again, that initial protest is really important. So this is the base period that we were speaking to earlier. The state does look at the first 4 of the last 5 as their base period. So if those wages, if they've contributed wages during those periods, then they would be eligible for that unemployment. So again, if we hired a bad apple, let's try to get rid of them as soon as we can to avoid paying those wages in that base period, okay? We still want to make sure we do it cleanly. We still want to make sure we do it legally, because we don't want to get lawsuits and things of that nature. But if there's some issues that, relate to their performance, things of that nature, then we want to make sure that we eliminate that job as soon as possible. It kind of gives you a little grace period. We don't like counties using the probationary period word, because then that tends to, when they do really, really good in that probationary period, and the day they're off probation, they kind of maybe not perform as well. So we don't like to use probationary periods. We don't encourage counties to say you're on probation. We just want them to know that, hey, yeah, you're hired on. As long as you continue to perform the job, then you can continue to have your employment. So using that probationary period is not ideal. Some counties do it, it's fine, but just keep in mind that sometimes after that day, that 91st day, they may go crazy, right? Also too, with the wages, after about 6 weeks is what we estimate. After that is about when they'll start contributing to that base period, so it could cost, and they could become eligible during that time. So the sooner you let them go, the better it is. I do want to point out too, and this kind of, a lot of the counties, they kind of were like, well, why aren't we getting a refund? If a former employee wins on the initial protest, right, we've submitted the documentation, the employee wins, we're gonna appeal it. Say it's appealed and it's overturned, then from the time that they received that favorable decision for the employee, former employee, they're gonna start getting those wages paid to them, right? If we overturn it, we get it overturned in the appeal hearing process, then the former employee will owe back those wages, and the county will receive those wages back. But that's a very lengthy process, and it's not actually money exchanging. It's considered credits towards your unemployment, and the only time you'll see that is the next time you lose an unemployment claim. Okay, those credits are gonna be back. Or the next time that former employee wins unemployment, they'll have to pay that back. So keep in mind, we wanna try to win on that initial protest. Have I said that enough? When do we wanna try to win?
Original protest.
There we go. So, but because a lot of counties are like, well, I won, they need to pay me back. Well, it doesn't technically work that way. It's credits for your unemployment fund, and you don't actually see that money exchanging hands. So this is the minimum and the maximum amount. This is for 2019. This does change every year. Last year it was like 12,000 and some change, so it does go up. The state does look at and change that every year. The minimum amount is $68 a week, and the maximum is $507. So they are eligible for up to 26 weeks, which could be a potential liability of $13,182. So 13,000 is a lot when you're looking at that, especially if you're losing a lot of unemployment claims. So we want to make sure that we're doing our best so that we're not having to pay that out. And again, that's the max liability because they can get up to 26 weeks. But if they only get it for 2 weeks, they go find another job, and of course it's not going to be that full amount. So disqualifications. This is the most effective way to reduce your claims, is making sure we get some type of disqualification. It's going to reduce what you're paying because you're not going to have to pay out if we get a disqualification where they're not eligible to win that unemployment. You're not going to be charged for it. The credits, that's what we talked about, the credits for that hearing. So we don't want to have to worry about getting credits back. We don't want to lose on the first one. And then it also forces that employee back into the labor market. So if they win unemployment, they're like, oh, okay, I can't sit at home and just collect a check. I gotta go hustle a little bit more and find a check, right? Or find a job to get that check. So it kind of forces them back into that labor market. And of course, it can also be helpful when defending other cases. So unemployment is gonna be your first line of defense if you get some type of discrimination charge, some type of lawsuit, anything of that nature. By that time, if you've lost unemployment, it's gonna be really hard to defend any other type of lawsuit, right? Because you lost unemployment, you couldn't defend unemployment, so how are you gonna defend some type of lawsuit or EEOC claim? Yes, sir.
If they have won their claim, or not won their claim, if they've applied, and they're getting $200 a week, and then they also find a job where they're now making $400 a week, does the unemployment continue?
No, unemployment will stop once they're employed again.
If they get a job and they're making we're paying $200 a week, but they make $100 a week, do they continue to get $100 a week on unemployment?
No, if they're back in the labor market and they have a job, then they,
Stops it.
it does stop that. So anytime a organization hires someone, they do have to report that to the Texas Workforce Commission to report, hey, they are employed, because that's when it starts their wages for their base period too. So once they're back in that labor market and they have a job, then that claim is over.
Thank you.
Yes, sir. So other grounds for disqualification, we want to make sure they're quitting without a cause, right? They just quit, they just left, there's no reason. One thing I will point out, it's really important if they quit that we get something in writing, right? We get some type of documentation from the employee. Because if an employee doesn't have a reason, or even, we look at will, right? We're all at will. They're at will, fire them. If you fire someone for at will, you will not win unemployment. You won't, okay? They're at will. So I caution supervisors in using that at will. You can, it's there, it's legal, as long as you're at-willing them for a legal reason. But I encourage you to try to find some type of job-related reason to win unemployment. Sometimes, I get a supervisor, they come to my office and they're like, listen, I just can't figure out what it is about this person, their personality isn't, there's something. She's like, I just want to get rid of them for at-will. And I'm like, okay, but just know it's going to cost us some money. We can do it. You're not terminating them for any type of protected class. You're not terminating her because it's a woman. You're not terminating them based on their race, anything of that nature. This person is just not meshing in that department. So you could use at will, but you will lose unemployment, okay? So keep that in mind. But I would encourage you, if you do any type of resignation, you've got employee, like I'm resigning, I'm leaving, even just having a standard blank resignation letter that just fill in the box, with their name, with their date, the reason why they're leaving. If you're firing someone, or if someone quits and you don't give them a reason, you're just saying, just go. You're fired, you're eliminated, or whatever. What reason do they have? They don't. So they can make up one, right? And then you have no documentation or supporting documentation for it. So you don't want to terminate someone for no reason. You want to give them a reason so that they have that reason, because that's what they're going to take to unemployment. If you don't give them a reason, they could make up a reason, and that could get really scary, right? Because you don't know what they're going to make up, right? They're discharged for misconduct connected to the work, so it's something related to their performance. They couldn't perform the job. They had a policy violation, something of that nature. It's job related, that misconduct, and that's why you're terminating them. They would not win unemployment for that as long as it's job related. Or refusal for suitable work. So in the case that you have, a good example was we had a deputy that was injured on the job and unfortunately affected his hand that he shot his weapon with. So he was no longer able to shoot a gun. So he could not perform the jobs of a deputy. So he was offered a job to work as a dispatcher. They were going to keep his pay the same. They were going to honor all that because he had an unfortunate work accident, right? But he just flat out said, no, I don't want to be a dispatcher. So he wouldn't take the job, so therefore he couldn't work. So he was refusing that suitable job that the county was willing to keep him on in a different position. But because he refused it, then we won unemployment. He did not win it, okay? He spoke very ugly about dispatchers and said he didn't want to do that, so that was his decision. But unemployment's going to look at, in that hearing process or in that suitable or that initial protest, is there a job for them? If not for this, would they still be employed? So yes, there was a job for them. I've seen it happen that a hearing officer will say, well, can he come back and start work tomorrow? Yes, he's more than welcome to come back and work tomorrow. Then they're not going to win. We're going to win, right? So you want to make sure there's a suitable job for them if you offer that. If you're offering that suitable job, making sure that that is in writing. It's documented that I'm offering you this job. I recommend that for a job offer too, kind of off topic, but any type of job offer you're making, that it's in writing, what the position is, what the pay is, and all of those details, so that they have the right to refuse that if they don't want to work it. But you have that documentation that yes, you did offer them that other employment with the county. So how do we get disqualifications? Employees must be aware of your policies and procedures. I know you guys are kind of looking at your policy manual, kind of looking at adding some new stuff. So it's really important that your employees are aware of that policy. They are aware of any changes that may be made to that at any time. Spoke with Lucy and Donna earlier. It's one thing that the unemployment will look at when you're submitting that documentation for unemployment, and you're submitting, the justification, everything, and say it is a policy violation. So you submit that acknowledgement form. If that acknowledgement form was signed 10 years ago, Do you think that they're gonna remember what those policies were 10 years ago when they signed it? No. So unemployment looks at anything older than 10 years, they don't like to see that date on that acknowledgement form. So I do encourage, anytime you're making that policy change, to get that updated acknowledgement form. And then I did recommend, Lucy, maybe at open enrollment or once a year, submitting just the acknowledgement form to the employee and reminding them, hey, the policy manual is posted online. You can get a copy from your supervisor or get a copy from your HR department, just so that they're aware, hey, these are the policies from the county. You have a question, sir?
I do. There seems to be some opinions about employer's policy. Does the county's policy override an elected official's policy? Or who's the employer, I guess, in the question?
So counties are different, right? Each elected official can kind of run their office the way they see fit, as long as they're not violating any federal laws or state laws, right? EEOC unemployment, they look at the county as one entity. So I would recommend, not to say that one overrides the other, I would recommend, your basis of your county policy is gonna have your benefits, those are controlled by the court. Filing harassment, things of that nature is just a general policy for the county. Such things as like your dress code, y'all have a dress code in your policy manual, but it's real vague, right? The elected official has the discretion to make their dress code what it is, or their procedure for calling in, or their procedure for asking for time off. I would say that they kind of work together. You don't want them to contradict each other. You want them to kind of work together, because when you're submitting an unemployment claim for a policy violation, we terminate them for a policy violation, they're gonna ask what policy. They're gonna ask for that acknowledgement form, things of that nature. So if you have a policy that the employee thought they had to follow because that's in the elected officials policy, but the county policy contradicts it, what's the employee supposed to do? How can you hold them accountable for that policy when they're told two different things, right? Because they've signed the acknowledgement form for the county because it has other things in there like their benefits, retirement, things of that nature. So I would encourage that the elected officials, if they do have other policies, that's fine, they can have that. Just making sure they don't contradict with the county's policy.
So what's your recommendation if they did?
I would recommend having a discussion with your county attorney. Yeah, I wouldn't recommend that the elected official, and elected officials, you guys can run your department how you see fit, right? As long as you're not violating any federal or state laws. But at the same time, you need to understand that you, as a supervisor, not even just the elected official, anybody in your office that has supervisory responsibilities can be held personally liable for any type of claim. So if this comes to a lawsuit, it comes to an EEOC claim, and the judge can get up there and say, if not for your actions, this wouldn't happen, so I'm gonna hold you personally liable for this. And so it's really important that the elected officials and supervisors are kind of understanding the laws and that their policies are following those laws as well. But I would not recommend that they contradict. And Lucy and I kind of talked about it, and a lot of those ones that elected officials would have internally are very vague in the county policy. So as long as they're not contradicting, I think they would be okay. But at the point that you're filing an unemployment and you're submitting that documentation, the employee should know and be aware. And I've got the disciplinary statement form, like a sample one, that I was gonna go through with you guys. When you're writing someone up or there has a policy violation, you wanna give the employee the benefit of the doubt that maybe they should know, right? So giving them verbal warnings like, hey, you need to be aware, you violated this policy. I told you that, you need to call in, you're not allowed to text in, or you're late every day for the last 6 months or whatever. We need to address that. So at that point, they know what policy that they're violating. Does that answer your question? One of them's not going to override the other. I'm not going to say that, but they need to work together. It's always a big gray area with elected officials, right? Because they kind of own, but anytime that lawsuit comes up, they don't care that it's an elected official. The county is the employer. Policy. So policies, they must be consistent, applied to all of them. You're not treating someone differently. This person doesn't have to follow this policy, but this person has to follow this policy. You want to make sure that your policies that you have in place are actually being practiced. So you don't just have a policy in place just to have a policy in place, that you're actually following that policy. And reviewing those policies every year, every 2 years, just to make sure, hey, are we still doing this? If we're not still doing this, maybe let's change what we're doing, let's change this policy, or whatever the case may be, making sure that they are uniformed. And again, the employees must be given a fair chance to meet those requirements. So you don't want to just say, hey, I gave you this policy 2 years ago and now you started violating it and you just fired them that day. You want to make sure that employee knows and they're aware. Back to the at will. We're at will. You're fired, you're done, or whatever. Unemployment wants to look at progressive discipline. They want to know that you have made the employee aware of whatever the situation is, a performance issue, a policy violation, whatever. They want to know you've made them aware, you've given them a chance to correct it, they haven't corrected it, and now we're terminating them. That's what unemployment wants to see. They don't want to just see they made one mistake, you got fed up and you fired them. Okay, chances of us winning unemployment are very slim with that kind of situation. So we want to make sure that they're aware of what the issue is, what their performance, what they're not performing well, or what policy they may have violated. Documentation. It's very, very important. Documentation is key for unemployment. I don't know why I have it. I've got 2 slides on unemployment, or on documentation. Sorry, I got confused. But again, the documentation is really important. Like I said, the former employee has up to a year to file that unemployment claim. So I encourage you to gather your documentation, get all that together as the situation is occurring. Even documenting, and I know this sounds really weird and very tedious, but even documenting good behavior. Because the point for unemployment is to prove that their inability to perform the job. So you have an employee that's worked for you for 10 years and they've done a great job, you've never had any issues with them. Now all of a sudden they just stopped doing their work. They just stopped. So it's going to be on you to prove they were able to do the work prior. Now they just stopped doing it. Like what's going on, or why you terminate them because they just stopped doing it. So even documenting good behavior to show that, hey, they were able to do the job before. I've trained them during the training process of a new hire, that you've trained them on these procedures, you've trained them on how to do things, and they've acknowledged it. They're doing well, doing those check-ins with them, those kinds of things. That documentation is just as important. Just as important as if you have a bad situation, you need to document it. Okay, you want to make sure that some type of incident happens in the office or some policy violation or whatever the case may be, that you're documenting that as well. That's going to be your defense in an unemployment claim, in a lawsuit, an EEOC claim, any of that nature. Those documentation is going to be key. If you don't have documentation, how can you prove it? Right? What's there to prove? It's just, we're going to make it up as we go. Doesn't really work out that well. I will tell you a story, and before I joined TAC, I was an HR director for a county, and I still am real bitter about this one unemployment claim, and I'm going to tell you about it, and I'm going to try not to get mad about it. But it was all because I was missing documentation, So we had a drug and alcohol policy. A supervisor, it was not a DOT, so those are a little bit different. So with CDL drivers and stuff, those are a little bit different. But this particular employee, the supervisor came to me, he's like, look, something's going on. He started acting funny. I think he's on drugs. I think he's taking something. And, we documented it, that what we noticed, things of that nature. So we approach the employee and we tell him, hey, we're going to send you for a drug test. We have reasonable suspicion to think that there's something going on. Your behavior is a little erratic. You're not acting yourself. And he flat out refused. He was like, no, I'm not taking a drug test. I'm not taking a drug test. You can't make me take a drug test. And we said, okay, we're not, but you're fired, right? We're not going to make you take a drug test, but you're fired. We have reasonable to think. And so if they refuse, it's as if it was a positive, right? Well, little old me didn't get him to sign a little form that I asked him to take a drug test. and he refused to take the drug test. And so all I had was the documentation of us asking him, of our observance of his behavior and things of that nature. So I do encourage documentations and forms for anything, because if you don't do that, that employee is gonna make up whatever they want on the other end, and that's exactly what he did. He told them that I never asked him, or his supervisor never asked him to take a drug test. So you wanna make sure, little things like that, we've asked him to do something, acknowledge that I'm not taking it. A little trick that one of the other HR consultants, she recommends, is if they refuse to sign something or it's some type of disciplinary form, they're like, nope, I'm not signing it, I'm not acknowledging that, flip it over on the other side and say, well, can you write down why you don't want to sign it? On the other side, get their signature, it's done.
What if
And
they
then
don't do that?
If they don't do that, then of course you can have a witness. The witnesses usually don't stand as strong as their actual signature, but making it in a way that's like, that's fine, you don't have to agree to this, you don't have to, but just can you write and tell me why? Can you explain to me why? And just kind of give them that option. Everybody, I was in a training yesterday with our law enforcement consultants were doing a training, and they were treating some of the deputies and talking about how to, when most of the time when our law enforcement is encountering people, it's not a good situation, right? And so when you're writing someone up or when you're terminating someone, they're not happy. They're not going to be, pleased, and accept it gracefully, right? They're mad, they're angry. So we just want to make sure that we're still talking to them in a manner that we make them feel comfortable, that we're like, look, this is what happened, I'm really sorry, but this is what we've done, things of that nature. And sometimes if you just ask, well, hey, do you mind writing down why? Would you explain your side? Will you say why you don't want to or why you're refusing? And sometimes that will help.
I was taught long ago is if you couldn't get them to do that, to actually write on the form, employer refused to sign, date it, time it, and then get a witness. So if 5 years down the road you come up with something, you actually have, better than just having a blank form.
Correct.
Right.
Put something on there. Have that witness, yes, I witnessed that they asked them to sign, they refused to sign. Yes, most certainly if they won't. But try that little trick of just flipping that paper over. I've seen it work a couple of times, and you've got that now on that form. Yes, ma'am.
You said when you were talking to them, you're trying to keep them calm and stuff. But one of the things you mentioned was you made the statement, I realize that, what's going on, I'm sorry that you feel like this. Recently went to a seminar in a free world environment, and they said that if you use the word I'm sorry during a disciplinary setting, that you are admitting from an employer standpoint that you are doing something wrong. Is that true too in the county?
I mean, I guess it could be. I'm a very passionate person, so I'm gonna say I'm sorry. I don't know that if that would be admitting guilt. Now, you don't want to, in a situation, you don't want to admit guilt of anything. If there's like, especially in certain situations like harassment type claim, you don't want to admit anything of that. You want to say, we'll look into it, we'll investigate it, those kinds of things. But from my perspective, especially from the HR, by the time they come to you guys, just kind of like consoling them and saying, I understand this is difficult, and kind of just asking them, to that point I was saying to get them to say, will you just explain why you're refusing, or you just explain why you don't agree. So if you don't want to say I'm sorry, I don't know, to be honest, if that's technically admitting guilt. I mean, I've said it a couple times to employees I've fired, and I've still won unemployment. You don't want anybody to lose their job, right? You don't want to fire somebody. That's never a fun conversation. That's never a fun topic. So just being mindful of that and trying to convince them to write or sign on that, so that you have those documentation. Questions on that? And I think we kind of talked about all this, but documentation, the state wants facts. They don't want a conclusion. They don't want your opinion. They want facts. What happened, what was said, what occurred. That's what unemployment's going to be looking for. Okay, so you want to keep it straight to the point, straight to those facts, which is really important. Again, making sure you're doing that right when it happens, keeping it fresh on your mind. Even if you never get an unemployment claim, or 6 months down the road, it's filed, and you have to respond to it and try to jog your memory. If you wrote down the facts of the case, then you just go back and read the facts of the case. So, so make sure that you keep it factual. The employer, it's on the employer to prove that misconduct, so keep that in mind. So you're the one that's terminating them, you're the one that's documenting those things, so just keep in mind that it's on you to prove that to unemployment when you turn that into unemployment. So just some tips on the documentation. We want to keep it factual. We want to use descriptive words. We don't want to just keep broad, vague words. We don't want to use words like attitude and behavior. I don't like your attitude. What don't you like about my attitude? I roll my eyes at you every time you tell me to do something. I ignore you when I'm talking to you or when you're talking to me. I slam my desk drawer every time you ask me to get something for you. You're real snippy in the way that you respond to me. So those kinds of words, use those kinds of descriptives, not just a blanket, I don't like your attitude. If you have like a customer service type thing, and you're not, the word just left me, in a customer service, you're like, you don't have good customer service skills. Well, what does that mean? How do you talk to those employees? Describe what happened. Describe how they're acting. Use those verbs and those descriptions. And when you're writing them up, when you're using that documentation, make sure the employee is aware of, you did this, and I need you to do this. Like, I need you to not roll your eyes at me when I ask you to do something. Okay? Make sure the employee knows and understands what they want, what you want them to do. What do you want that outcome to be when you're writing them up? And then focus on what the employee does. Like I said, using those descriptive words, describing what they're doing. Think about whenever you are filing an unemployment claim and this documentation comes into play, you want to make sure that you're painting the picture of what happened to that hearing officer or to that unemployment on that initial protest. Because by the time it gets to that hearing officer, all they're hearing on the phone is that sweet little voice that they didn't do it and them denying everything. So you want to make sure that you paint that picture of exactly what happened and exactly why you wrote them up, exactly why you terminated them, okay? I've heard it happen. I'm like, oh my gosh, that person is like an awful spawn of Satan, and they just turned on this angel. Like, what happened? But they're trying to win unemployment, okay? So you want to make sure that you are very descriptive in how you're documenting and how you're going to prove that case. So again, the same thing, things you want to look at: argues with other coworkers, makes inappropriate jokes. Those are good things you want to avoid. Like, don't use maintain a positive attitude. Don't use be a team player. What does team player mean? That's open to interpretation, right? We don't want to use words like that. We want to say they wouldn't assist the assist their coworkers while the coworker was helping a customer. They refused to assist, or they refused to assist their coworker with a project that I asked them to do, things of that nature. We don't want to use team player. It's a pretty broad topic, okay? All right, so I have this disciplinary statement that I handed out at the front. This is our TAC form. You're welcome to use it. I can email this to you so that you have it. The only request we do ask is that you take Texas Association of Counties off the bottom. We don't like to see these in lawsuits and unemployment claims with our names on it. So this is a sample form for you to use. Again, if you want it, I can email it to you. But this has pretty basic information on it. You're welcome to add more to it. But talking about what's important to list on that disciplinary statement, making sure that you have the date of the incident, the date that you're writing them up. Those dates should be pretty close together. You don't want to have an instance where you need to write an employee up, but you're like, I'm busy, I don't have time, I know they messed up, I don't have time, I'll take care of it next week. That is not going to look good in unemployment, and you will lose. So some advice for that is, if you have an employee that you know they messed up, whatever the case may be, and you don't have time to write them up or assess the situation then, send them home. Say, take them out of that situation, say, look, you've messed up, this is a policy violation, or whatever the situation is. Send them home, and then ask them to come back tomorrow, and then you can write them up tomorrow. But if you leave them in that job, knowing that they have messed up or misbehaved or whatever the case may be, it's not gonna look good that you put them back to work. Okay, so send them home for the day, and then you wanna address that occurrence immediately as soon as you can. So, and then actions taken, what did you do? Did you coach them? Did you give them a verbal warning? Anything of that nature? Describe the incident. What was it? Were they tardy? Was it a policy violation? What was it? Describe it here. And then, of course, that explanation. And sometimes you may need more than these little bitty lines, and that's okay. Attach a sheet of paper to it, but this is just kind of a little guideline for you. Having that corrective action plan. What do you want the employee to do to fix it? Stop rolling your eyes at me when I talk to you. Okay? Be specific. Be clear cut with them. I don't like the way that you talk to me in that manner. You were very disrespectful. You kept rolling your eyes. You would slam in your drawers. Things like that. Okay? Disciplinary action if it's not corrected. So the next time, if you don't fix this, I'm giving you this warning. If you don't fix this, what's going to happen next? They need to know what the expectation is. They need to know what the outcome is going to be. And then there, if the employee wants to make any comments, there's a little section for the employee to make your comments. And then, of course, a signature. Having the signature of you, the supervisor who made, who wrote them up or whatever, and then, of course, the employee having that sign is very, very critical. Again, like we discussed earlier, if you can't, having a witness or turning over the paper and asking them to sign that as well will help as well, okay? Any questions on the form here? I also gave you a little handout just of disciplinary reminders, just some things to consider. You know, we live in sometimes we have some sensitive employees, so we want to be aware of the laws, and you don't want to violate any federal laws, state laws, anything like that. So this is just some helpful reminders for you as a supervisor on there. So with the disciplinary forms, everything should be documented, right? Even if it's a verbal warning. I'm giving you a verbal warning. You want to make sure it's in writing. I have some supervisors that they're like, I don't want to write all this up for a verbal warning. Okay, but if it's not documented, when it gets to unemployment, it probably didn't happen, okay? Word of advice I always suggest to you, if you don't want to go through the form on a verbal warning, send them an email. Send the employee an email with a read receipt. Hey, as a follow-up to our conversation today, blah, 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 blah. This happened. I expect you to fix it or you'll be terminated or whatever. Follow that up with an email if you want to. Make sure you do have a read receipt so that you have proof that they actually got it, okay?
But even if, say it's a field person, they don't have computer access or an email, send yourself an email, because it's dated, it's time stamped, and it's helpful versus nothing else.
Correct. Have something. Correct. Yes, sir. And again, like I said, do not procrastinate. Make sure you handle it as soon as you possibly can, as soon as the incident occurs. Don't put it off. It does not look good if you're like, well, they are in the middle of a really big project and I need them to finish that project, so I'll terminate them after that project is done. You're not going to win unemployment, okay? And you'll probably end up getting some type of suit, okay? So you, for those types of reasons, that's selfish reasons for you, right? They violated something, they did something that they need to be addressed, need to be written up for, but you chose not to because you needed them to finish their work, okay? Or you're short-handed, short-staffed. We want to be careful of that. So the disciplinary forms, again, it shows that an investigation was conducted, who conducted it. Again, if you'll use this form or something very similar to this, you'll have all of the topics that you'll need for that. I will tell you we had a county that it was in the district clerk's office, and the district clerk's office was upstairs and the court was on the second floor. And the district clerk was a small office, she only had a couple employees, and there was a couple employees, they just did not get along. They hated each other for some reason. And they're down in court one day, the district clerk is down in court, and she hears banging and slamming and screaming and hollering upstairs coming from her office, so her and the bailiff run up there, and the two girls are in a full-on cat fight. Punching, kicking, screaming, very, very intense cat fight. Well, the district clerk they pull them apart, she writes them up, she tells them, y'all can't act this way, if you touch each other again, I'm going to fire you, okay? So it was enough that it was a pretty intense fight, but she didn't want to fire them. But so she said, if you touch each other again, I'm going to fire you. A couple weeks later, same situation, she hears them, they're down in court, she runs upstairs. Well, they're not touching each other. They are throwing things at each other. They're slamming the desk, but they never touched each other. Well, she fired them. They won unemployment because the second incident was not worse than the first. So you want to make sure that if there's an immediate action, she was going to have to wait at that point now until they touched each other to terminate them, because that's the language that she used. So you want to be very careful in that situation. That the fireable offense has to be bad or worse than the previous, anything previous, okay? So just keep that in mind. She knew, she said, I know I should have fired him the first time, but I was trying to give him a chance. Okay, so just be aware. Yes, sir.
I should have spoke up and said something a while ago, but when you were talking about documentation of the emails, something that we did at the sheriff's office years ago when I was there, we had a couple incidents where employees would get emailed something and then they would, well, I never got it. So what we did over there to get around that problem, we put it in policy. You're required every shift you work to check your county email. And that way, if the response was, I didn't check my email, well, then you broke another policy.
Yeah.
And that was a way to get around that and to make sure that they were checking it.
Yeah, that's an option too. Yes, sir. Thank you for that. We've kind of talked about this out of order, but just keep in mind that the documentation is really important. And again, any documentation that you may have for when your unemployment, if it does become an unemployment claim, those hearings, they are recorded, they can be transcribed and used in other cases. So if we can't win unemployment, the chances of us winning a lawsuit are going to be very hard. So we want to try to win unemployment as much as we can. But it's hard to say, well, there's a justifiable reason why I terminated them, so I want to win this lawsuit, when the state looks at your unemployment claim and says, no, it wasn't, you shouldn't have fired them for that. Okay, so we want to make sure that we're looking at each situation when it comes to writing up in terminations. So misconduct versus inability, we kind of talked about this a little bit too earlier, but poor performance is your fault, not the employees. Like I said, if you can prove that they were able to do it, able to perform the job, and they stopped doing it, then that's them not doing the job anymore. But if you hire that employee and they have never been able to perform that job, then that's just a bad hire or not enough training or something, right? So that's going to be on the supervisor on the county for that poor performance. So that's why I say it's really important. If they're just not able to do that job within the first couple of weeks, and you can tell in the first couple of weeks if they're not getting it. If things aren't clicking and they're not getting it, you can tell that they're not going to be able to perform that job. Okay, and it's okay to let them go. Like, I hired you to do this job, you're not able to do it. You know, unfortunately, your services are no longer needed here. But it's okay to do that. But a year down the road, they're still performing the job really bad. They're still not able to do the job. It's going to be a little bit more difficult. So we want to make sure that we're looking at that. Must prove employees was capable at some point during employment. Sorry, that's again where I said, you know, it's a good idea to keep records of the good things that the employee does. You know, that yes, they were able to do X, Y, and Z function, or, you know, I trained them on this day. I followed up in 2 weeks. They acknowledged that they understood. They were still performing the job well. That's going to help you down the road, even 10 years down the road. Hey, they were able to do it once before, and now all of a sudden they just stopped. They're just not doing it. They're just not paying attention. Okay, so that's going to give you some leeway in that unemployment. Did he, she, knowingly do anything to cause the termination? Is the employee aware? Y'all made them aware of what policy they violated or whatever? Was the termination on them, or is it just because they just couldn't do it? So it's up to the employer to determine and fight and defend why you made that termination, why you made that separation. So keep that in mind. This is what we have to prove. Quits. I quit, I don't work no more, peace out, I'm gone. Okay, alright, they can do that, right, they can quit. Again, like I said before, let's make sure we get those in writing. Good idea to have that resignation letter, require that resignation letter that states why they're resigning, or that they just got another job, or that they just don't want to work there anymore. It doesn't need to be detailed, but you need to know that it was generated by them. They made that decision. If it wasn't for them quitting, they'd still be working there. Nothing that, you know, you weren't gonna fire them.
That's gonna be hard to get though,
To get a letter of resignation?
to I quit. If I'm upset and the judge, he's my boss, that's why I'm bringing him in. I'm not gonna write anything for you. I'm already upset at my boss. It's an at-will state. I quit. That's all you need to know. I won't be back. Here's my stuff.
You won't have to quit, you're fired.
That's even better because you didn't write me up. I'm going to get unemployment.
Lloyd, that's a good point that he's making there. What if the judge walks in one day and he's upset with him and he said, Al, I know we've been friends for 10 years, you've worked for me up until now, you've done a good job, but I just don't like the way you handle the situation, it's time for you to go. What do you mean it's time for me to go? Well, other than me firing you, it would look better on your resume if you just quit.
Right, so resignation in lieu of termination is a termination.
That's right. That's exactly.
Yeah, you're gonna go they're gonna win unemployment. So I know you're trying to be nice and you're trying to make it look good on their employee file, but I would encourage you to go through that disciplinary action and do that termination. Because resignation is still a termination. Because if you didn't ask me to resign, I'd still have a job. So therefore I'm fired.
The way TWC explained it to me once was if the employee did not have an option to stay, they were fired, period.
Correct, no matter what it says. It may say retirement, it may say resignation, but if you ask them to turn in their resignation, that is a fired. You fired them, okay? So back to the point of, yeah, you may not want to,
No,
maybe.
it's not, I don't want to, I am not going to.
Okay, and that's your decision.
Right.
But I would encourage a supervisor to ask, like, hey, well, do you mind, like, telling me why? Do you mind, you know, writing this down? And I'm not, you don't have to, but maybe some employees
So
will.
how do we fight that?
I would encourage, maybe, do y'all do exit interviews? Do they go to the HR office and do exit interviews?
We actually have a sheet that they can fill out in HR, and some of them will, and some of them says, I would just rather not say anything.
Okay, so maybe encourage them to, okay, well, you need to go see HR, and then HR can maybe work on, well, do you mind writing this? Especially if they have like the blank fillable resignation form. Hey, do you mind filling out this as letting us know why you're quitting? Sometimes it may be a little bit easier for HR to get it than the supervisor because you're really mad at him, so you're not gonna talk to him anyways. So it may be sometimes easier to get it from HR to get it to do that extra interview where they're gonna talk to you about your retirement, they're gonna talk to you about your health insurance, they're gonna talk to you about all your other benefits and stuff, separating. So at that point, by the time you get to them and you're doing all that, you may have calmed down a little bit and you may be willing, I hate the judge, period. You know, whatever you wanna write. That's what I gathered from. So, but at that same time, it's still something in writing from the employee that you were mad and you quit, okay? So sometimes the HR can kind of mitigate the situation and get some information out of the employee. Okay? They may not want to give it to you because they're mad at you. Or you may not want to give it, but.
When I leave, here's your stuff, see ya.
Well, at least they'll stop by and see HR because they need to talk to
I'll
you about
give it to him.
they need to talk to you about your retirement and your health insurance
I'll
and
call
all
them.
All right, refusal to work. We kind of talked about that earlier too, making sure that, you know, if they cannot perform a job and you're going to offer them another job and they're refusing to take that job, that you're documenting that you've offered them another position, and you're documenting that they don't want it. You've offered it to them and they're still refusing. But so now they're going to go to unemployment and say you fired me because I couldn't do this job. But then we're going to say no. We took you out of that position because you couldn't do that job, and we're going to put you in this position. You chose not to take this position. Okay, so you want to make sure that that's documented as well. So refusal of work, if you are offering them another position, this is a good idea of things that you need to have in that documentation of you've offered them the job, what the job consisted of, what the pay was, when you expected them to report to that new job, all of those details, having that in writing, so when they say, nope, I don't want to do it, you say, well, I offered it to you, because again, unemployment is going to ask, is there a job for them? Would you rehire them tomorrow? If that answer is yes, the chances of us winning unemployment are a lot higher, okay? So some separation issues, reasons why you probably would not win unemployment with separation, looking at absenteeism. Say you wrote someone up for being absent, they've been late several times, you wrote them up. The day you terminate them, maybe they were in the hospital, or maybe the road was closed and they couldn't get there. So you want to be, timing is very important with absenteeism. It cannot be something that they could have control. They couldn't control that that road was closed and it made them an hour late for work. They cannot control that they were in the emergency room that the time they were supposed to report to work. So you want to be aware, if you're writing someone up for being absent, things of that nature, you want to be aware what's the reasoning that they were not there on that final incident. Okay, because that's what they're going to look at. Unemployment is going to look at that final incident. One thing I will also point out with absenteeism is if you have an employee that has worked for you, say, a year, and every Friday they show up 30 minutes late, every Friday, and you let that go on for a year. Then finally after a year, you're like, I'm so tired of it, they're just always late on Fridays, and you decide to write them up. Unemployment is going to look at that and say, you let them be late for a year, and now you're writing them up for it. So you set a precedence with that. So you want to make sure with absenteeism that that's addressed in the beginning. When does it become a problem? After a year it became a problem? Because I'm sure after a couple of months you're like, what is going on? Why are you late every Friday? 30 minutes late every Friday, okay? So you want to be careful with absenteeism. Now, those are really hard to defend if you kind of set that precedent that it's okay for them to kind of come and go as they please and be late. So you want to be aware of those policies that you have, or how they're calling in, or things of that nature. And making sure you don't terminate them at the last straw. Make sure you know why they were late on that last straw, and it was something that they couldn't control or they could control. Now, just because they overslept, yes, fire them. But if it was the road was closed, they were in the hospital, their kid was in the hospital, whatever the case may be, it was something out of their control. Oh, I'm not skipping. Part-time employees. Part-time employees could receive unemployment, okay? Temporary and seasonal employees can also receive unemployment. So we want to try to keep those temporary and seasonal employees limited, so then they wouldn't be eligible because there was nothing contributing to their wages. So keep in mind that they could, even if you're like, you knew this position was only for a year, and you knew this position was only, this time period or whatever, they can always go file unemployment. So just be aware of that. Because they don't have a job, right? Eliminate the job. There's a part-time position. They don't have it, they can go file for unemployment. Same thing, mutual agreement. That whole resignation in lieu of termination, that's a mutual agreement. Not going to win that in unemployment. Keep that in mind. We talked about this delayed for your convenience. So I don't have time to write them up, I'm busy, or I really need them to finish that project. That would be that instance you're not going to win unemployment with that. So you want to address the situation as quickly as possible. And again, that last infraction was not so serious. The incident with the girls in the cat fight, well, the second time they were just throwing things at each other. They didn't touch anybody. So the first time was way more serious than the second time. So you want to make sure if you write them up for something, that second time has to be more serious or the same serious level as the first one. So rushing through this, I'm sorry I'm going a little over the hearings, just the process of the hearings. Keep in mind that it is a formal proceeding. Witnesses are sworn in. It's a record. Typically what happens, and those hearing officers, I'm going to warn you up front, are not nice. They don't like you to speak out of turn. They don't like you to intersect when you're not spoken to. They don't like you to make comments about things if you're not asked a question. So just keep in mind they are very formal proceedings. So although you're not in a formal courtroom, you are on the phone. And sometimes at different times, depending on the hearing officer, sometimes it'll just be you and the hearing officer, or if they have an attorney, or if the county's attorney's on the line, or sometimes you'll still be on the phone and can still hear the former employees, their statements and things of that nature. So you want to be prepared for any questions that may come up. Typically, on the hearing, you do want your HR, because they're the one that submitted that information. You want the supervisor that actually made the termination, that had the first-hand witnesses, or any other witnesses that you may want. They witnessed the situation, or they were a part of that procedure, part of that termination, having them on the call as well. If sometimes, depending on the counties or depending on the claim, they will ask their county attorney to sit in, because there may be some legal stuff that comes into play. And sometimes those attorneys can think a little bit differently on the questions to ask, to try to stump the officer, or not the officer, but the former employee, and that'll give some more information, that hearing officer, that can help win. So I always suggest, if it's kind of a sticky little situation, maybe get your county attorney on that hearing with you. That they'll take testimonies from everybody sworn in, they'll take testimonies from everybody, and then usually they'll start asking the questions. They'll start asking each party different questions. Keeping in mind that they can get that recording, you can get it in transcript and written, you can get it in a CD, and it can be used again at a later date if any other type of claim comes from that instance. Because you are sworn in, if you lie, it's considered perjury, so just be aware, we don't want any blindsiding new evidence coming in the hearing. We want everything up front. Because when do we want to win unemployment? That initial protest, yes, awesome. So again, just making sure that you work with your HR department. They've been on several hearings, they can help, and if they need help, they have TAC that can help with those as well, or your county attorney or TAC legal can help too. So I hope I've answered all your questions. Do we have any other questions?
I don't have a question, I'd like to make a comment. On page 4 of your handout where you were talking about documentation, you were going through there and you used the term, you wanted them to fix whatever it was, and I concur with that. The fallacy that a lot of managers will use is the word improve, and I would encourage all of us to take improve out of our vocabulary and replace it with the word correct, followed by the word maintain. Because I want them to correct the problem of coming in late, and I want them to maintain that correction, because not every 30 days when you're late again, we're not going to come back and rehash this situation. So you use fix is fine, but fix and maintain, or correct and maintain, but if you say improve, and they've been late 10 times in a month, and now next month they're only late 9 times, they've met your qualification.
Yes, sir. I agree.
Just a thought.
I agree. Yeah, you want to be very cautious of the words you're using.
Yeah.
All right, any other questions? Awesome. I do want to point out too, just a public service announcement. So we have our regionals that we have various trainings and things of that nature. So I have information about that if y'all are interested. And then also I do have my business cards up here with my cell phone and email that y'all are welcome to reach out and contact me with any questions.
Thank you very much.
You're welcome. Is there anything else?
Can we keep the pins?
Yes. I have more if we ran out.
Laura, we want to go into discussing, I sent you the code of conduct policy that was created. And what is your opinions on that? And you've gone over our whole policy. What is your?
I did. I reviewed y'all's entire policy manual, and I did not see any red flags, any major concerns or that I had with that policy. There were a couple of things that I did recommend and write out, mostly some minor word changes, things of that nature, or updating it because there's some new laws that came out, so just updating some stuff. But I didn't see any overall issues with your policy. I think you guys have a good policy. Y'all have followed a lot of it, of the tax sample policy that we have. Again, I would reiterate making sure we get an acknowledgement form every time a new policy is made or a policy is changed, to get that updated and signed from everybody. Your code of conduct, I did not see any issues or concerns with that code of conduct policy, kind of giving them some expectations to act appropriately in representing the county in that manner. So I did not see any issues with it. I would always, of course, which I think y'all have, run that by your legal counsel, but I did not see any issues with it. Yes, sir. Anything else?
Thank you.
Awesome, yes, sir. Thank you. I appreciate your time.
Thank you.
Oh, that concludes the meeting. Is there a motion to adjourn? Any better? Is there a second? I'll second. All in favor? Aye. Meeting's adjourned. For the record.